Let the record reflect that the court is back in session in cause number M324-911. The case is South State of Texas versus Mamie Lee Guillory. Let the record reflect that Mamie Lee Guillory is present in court with her attorney, Attorney John West, and the state is present with Assistant District Attorney, Attorney Ray Shearer, and Attorney Andrew Hubel. Let the record reflect that the jury is not in the courtroom at this time. The court has completed the charge conference. State, are you ready?
Yes, Your Honor.
Defense, are you ready?
Yes, Your Honor.
We will proceed at this time with the trial of this case. Bailiffs, please bring the jury into the courtroom. Everyone may be seated. Let the record reflect that the court is back in session in cause number 324-911. Case is South State of Texas versus Mamie Lee Guillory. Mamie Lee Guillory is present in court with her attorney, Attorney John West. State is present with Assistant District Attorney, Attorney Raymond Shearer, and Attorney Andrew Hubel. State, are you ready?
Yes, Your Honor.
And defense, are you ready?
It's ready, Your Honor.
Okay. At this time, ladies and gentlemen, I will read to you the court's charge. Members of the jury, the defendant, Mamie Lee Guillory, stands charged by information with the offense of assault, causing bodily injury, alleged to have been committed in Jefferson County, Texas, on or about the 5th day of August of 2019. To this charge, the defendant has entered a plea of not guilty. I now give you the law that applies to this case. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. So that you may better understand the nature of the offense which the defendant is charged, I now define certain terms and words. The term bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally or with intent with respect to a result of their conduct when it is their conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of their conduct when they are aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of their conduct when they are aware of but consciously disregards a substantial or unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregards constitute a gross deviation from the standard of care that a reasonable, ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Mamie Lee Guillory, did in Jefferson County, Texas, on or about the 5th day of August of 2019, did then and there intentionally, knowingly, or recklessly cause bodily injury to another, namely Jessica Leanne Ivy, hereafter styled the complainant, by striking the complainant in the head with her hand, you will find the defendant guilty. unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question a bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberations, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. And the last page of the charge is the verdict form. Your foreperson will sign one of the two lines. Now, the line at the top, the statement at the top reads as follows. We, the jury, find the defendant not guilty of assault causing bodily injury. If that is your verdict, then you will sign, your foreperson will sign this line. The bottom statement states, we, the jury, find the defendant guilty as charged in the information of assault causing bodily injury. If that is your verdict, then your foreperson will sign this line. Does everyone understand? Okay. At this time, we will have closing arguments. State, you have the right to open and close. State, are you ready to proceed?
State will waive our opening is closed.
You're waiting.
Closing part.
Okay. And Mr. West, you may proceed. You have 15 minutes,
Thank you, Your Honor.
and I'll keep time.
Thanks, Judge. Good afternoon, everyone. There's a saying in our profession, as trial lawyers, that if the facts are on your side, argue the facts. If the law is on your side, you argue the law. Remember, that's father. If we argue the law, that's where we take this charge. We go through this, we nitpick it, we pick parts like, well, the evidence showed you this, but it doesn't mean that and all that. It's not what you have here today. You have a case of the facts, what happened or what didn't happen. Now, I think the evidence has shown you that no assault happened. And why not say that? Because you heard the evidence from the witnesses. How many witnesses did you hear? There are 4 witnesses. How many said the assault happened? 1, the victim. Everybody else said there was an argument, there was a disagreement, there was a disturbance, but no assault. Nobody hit anyone. The judge gave me 15 minutes. I'm gonna take 15 minutes. The evidence started at 1:30, like less than 3 hours ago. You've heard it all. It's fresh in your mind. I'll have to go back and it's not one of these cases where it's been days and days and I have to go, oh, you remember on day 1, this witness said that. You just heard the evidence. You just heard all the witnesses tell you. They were all there working the mailroom. For whatever reason, Miss Ivy was in a bad mood. You heard that from Miss Davis and Miss Guillory. You got mad at Miss Guillory. They started arguing back and forth. Finger gets pointed there. Bickering. Miss Davis walks and gets between them. And then at that point, Miss Ivy says that Miss Guillory reached around and slapped her. Miss Davis says, nobody reached around me and slapped anybody. Miss Guillory's like, I didn't slap anybody. Mr. Beverly, who got called here to make sure everything was okay, like, I didn't touch anybody. As far as they knew, everything was shut down and over with until they got called in by the prison officials to say, you know, what happened that day. Miss Ivy saying that Miss Guillory assaulted her. This is not a situation where Miss Ivy said that before Miss Davis got there that when they were private, something happened. Remember, she said it was in between when Miss Davis got there. It was standing between. That's when she got hit. Nobody saw that. And you want to say, well, you know, of course she's going to say it didn't happen. She's a defendant. You're right. That's what defendants say. Of course, the victim's going to say it happened because she's the victim, of course you say. So it really comes down to the other witnesses that came to you today. And who called those witnesses? State. They called those other 2 witnesses in here. And I mentioned things about Mr. Shearer and Boyd Iyer, that he's a good man, and I have a lot of respect for him, and I do. I have a lot of respect for that man. Great lawyer. And he could have not called those witnesses, but he called them. He wants you to hear all the evidence. He wants to put it all out to you and let you make the decision. And they were the best witnesses for us. They're almost like the witnesses we should have called. We might have called them if you didn't call them, because I knew what they were going to say. I talked to them. You heard me ask Miss Davis. I thought you didn't. Yeah, I knew what she was going to say. That didn't happen. But they're wondering why they have to be here for this. Miss Guillory did not assault Miss Ivy. You heard all the evidence. You've seen all the evidence. There's nothing here. Have they proved this case beyond a reasonable doubt? Remember the different birds we talked about in Boyd Iyer? You know, the more likely than not, different levels. Did it probably happen? Maybe happen. I think it probably happened. I don't think it's that first level. You know, was it probable? I don't think probably happened. There's no evidence of that. It'd be one thing if we had one witness say, yes, it did happen, one witness say it didn't happen, then you go, all right, well, maybe there's some dispute here. But there's no reasonable doubt here. It did not happen. You do not have enough evidence coming from that witness to say anything occurred. I hope you take that burden back with you and realize that based on that burden, you have to find my client not guilty.
Mr. Chair,
Well, obviously, I'm gonna disagree. Okay. May I approach over here?
yes,
That's nothing. You can't say that's not anything. That's an assault. That's evidence of an assault. That's evidence that was taken after or the day of, the morning of, when it occurred. It happened. We had Miss Ivy who came in and very meticulously described what happened. And he's right. Conventional wisdom would be, oh, don't have Miss Davis or Mr. Beverly come in because there's an explanation for that. And y'all saw some reluctance and testimony coming from them. In the case of Mr. Beverly, it was almost like pulling teeth just to get him to explain the chain of command. There is what exists, that blue curtain. You may have heard of this before, but it's where people in that profession, law enforcement and such, they trust each other, they depend on each other, and the idea that anyone would betray anyone else is unacceptable. What Miss Ivy did was spoke up when she was wronged. And that's unacceptable in their field. And you notice that Miss Davis, without any authority, walked Miss Ivy out and told her to go ahead and go. I'm sure y'all been employed at different locations. You don't just leave without supervisory approval. And that's exactly what it was. It was covering. We don't want this to go any further. And Miss Ivy testified that she was going to try and call, but she was not allowed to call. Don't do this. That's not how we do things, is what she was told. It happened. It's ugly. It's unacceptable behavior. Understand it's a rough environment. During Wardire, when we were talking about if anybody knows anybody, I worked 27 years with the Beaumont Police Department. Yeah, I've seen a lot of bad things too. It can wear on you. It can work on you. And sometimes people snap. And it's probably over something that's totally unrelated to what's going on. And my point is that we had witnesses that were reluctant witnesses because somebody snapped in the workplace and assaulted another employee, and that crossed the line. But they didn't notify the supervisors. It was Miss Ivy that notified the supervisors. It was Miss Ivy that contacted the sheriff's department. It was not going to be swept under the rug as much as they wanted to. Miss Ivy is the victim here. She's not just wildly accusing, she was put in a bad situation. Who knows why? And a lot of times these situations are because something at home happened or something somewhere else in the workplace happened and somebody snaps. But think about, and I told you at the very beginning, to listen closely to what they say. And in this case, almost as condemning of what was said as what was not said, and the concept that all three of them were trying to say nothing happened. Pardon the English, but that's not nothing. That's what happened. I don't know why, but Miss Guillory assaulted Miss Ivy. And then that blue curtain came in and tried to go home. Take care of yourself. Let's not do this. That's not acceptable. You've been asked to uphold the law. You've been given instructions, and that's what I'll ask you to do, is uphold the law.
Ladies and gentlemen of the jury, at this time, all the evidence, the court's charge, and the closing argument of counsel are before you. I'm going to hand the bailiff the charge together with a verdict form. They will be left with you in the jury room. Once all members of the jury are present and assembled in the jury room, the case is formally submitted to you and you may begin your deliberations. Now, before you step down, one of you, we mentioned earlier that in a misdemeanor case, there are 6 jurors. If you notice, there's 7 here. And that means that one person is an alternate. The alternate is not allowed to go into the jury room at the time. Now, if something happens, then the alternate will step in for the person who is unable to continue or to complete the deliberation. And the alternate in this case is Margaret Bradford. It's Bradford, okay? So members of the jury, you can step down and follow the bailiff into the jury room, and the court will stand in recess until the jury has reached a verdict. Everyone please stand. Is that? Court will be in recess